For the first time ever, the United States Supreme Court has 3 Second Amendment related cases in front of it that we expect rulings on throughout 2024. I'm going to cover very quickly for you what those 3 cases are, and then I'm going to cover something that I don't think anyone else has, which is what I think everybody's missing and what I think you should be looking for is the most important aspect and takeaway from all these cases. Guys, let's get into it. All right, so I'm going to go through these cases really quickly so I can get to my big point at the end. The very first case, United States versus Rahimi. This case already had oral arguments on it on November 7th, 2023, and should probably be the very first case to get a decision back here in 2024. Now, you're going to hear what this is about, or I'm going to remind you what this is about, and you're going to say, I don't care about this, fast forward. Oh, you should care. We're, of course, dealing with Federal Statute 18 of United States Code, Section 922, sub G, sub 8. I know that all of you know what that is, so I don't need to remind you that that is the law that prohibits possession of firearms by persons subject to domestic violence restraining orders. I know I do not need to remind you of that, so I won't. So the question is whether or not that law violates the Second Amendment on its face, meaning this is not an as-applied challenge, this is a facial challenge, so does it always violate the Second Amendment on its face? That's the narrow question. That's the tree. Here's the forest. The forest is this. Who are the people in that pesky little phrase, a well-regulated militia, being necessary to the security of a free state? The right of the people to keep and bear arms shall not be infringed. Who are the people? Are the people 18-year-old and up adult citizens? Are they 21 years old and up adult citizens? Can you be a prohibited possessor due to having a qualifying domestic violence restraining order against you? What about an involuntary mental commitment? What about a felony? What about a violent felony? What about a non-violent felony? What about the fact that you like to use cannabis or something like that, right? Are any of those things disqualifiers, something to keep you from being part of the political community, as we would say in law, of the people? Because if you're not part of the people, then laws and gun laws and regulations can affect you. So we're going to be getting to the aspect of who are the people in that case, and the court's going to be taking their very first crack at it. I do expect a reasonably narrowly tailored decision, but I'm going to be getting to the big thing I'm going to be looking for at the end. But just very quickly, I am expecting the court to probably issue a narrowly tailored ruling against Rahimi. But again, stay tuned to the end to see what's going to be really important coming out of this. The second case, Garland v. Cargill. For those of you on your lawnmower, Cargill is C-A-R-G-I-L-L. Now this deals with, on its face, whether a bump stock device is a machine gun as defined by 26 U.S.C. section 5845 sub B. So this deals with whether or not, if you recall, the federal statute, it's one function of the trigger, or a single function of the trigger, is what qualifies as an automatic weapon, what qualifies as a machine gun. Then in 2018, our good friends at the ATF may have moved the goalposts on this to talk about a single pull of the trigger. That, among other issues here, is the whole backdrop to Garland v. Cargill. That's the tree, and that's an important tree. But here's the forest. What are the limits on the ATF power? Because when the ATF is allowed to interpret like the judiciary, enforce like the executive, and now they're going to, in essence, rewrite the statute in their administrative code by redefining it from single function of the trigger to a single pull of the trigger, we now have a single federal agency who has regrouped legislative, executive, and judicial powers all underneath one roof. I think there's a reason why our founders decided to split those up. And look, I understand that there's lots of ways, and I'm sure examples we could all point out, where different agencies have been blessed to one degree or another to do something like that. After all, they're allowed to write their own code and regulations. But that cannot overstep and redefine congressional language that we call law and statutes, which is what I and many others think that the ATF is doing here when they move the goalpost of what is a machine gun from a single function of the trigger to a single pull of the trigger, from looking at How's the mechanical function internally of how a device is designed and how it works, to how do we look at the inputs of that device? Because that's the difference between a semi-automatic firearm and 10 years prison in this particular case. But that's also the difference between one particular administrative body like the ATF being able to group all aspects and functions of government beneath it versus only having one or two of the three. So what's going to be the check not only on the ATF power, because if the ATF gets away with this, you can only imagine how many other of the 400 plus administrative agencies out there and sub-agencies might be looking at this decision as crucial to their plans next. Oral arguments in this case are scheduled for February. It's been scheduled for 10 hours across 5 days, beginning February 20th and ranging through February 28th. Show your support not only for this channel, but also the Second Amendment. Hit that like button. It does more than you know to not only help our channel grow, but also gives important feedback to myself and of course Derek behind the camera about what kind of content you want to see us make. And of course, if you just found us while browsing through, don't forget to hit that subscribe button if you enjoy this content and you want to catch more of it moving forward. I look forward to joining in the discussion section after this video. Right back to it. The last case, National Rifle Association of America v. Vullo. This is a case that has not gotten as much attention because even though we're talking about the Second Amendment, on its face, it's actually a First Amendment case. But wait, very quickly, for those of you who don't know, Maria Vullo was the superintendent of the New York State Department of Financial Services from 2016 to 2019. In her role there at that agency, she basically led about 1,400 employees that oversaw regulation of New York's financial services industry across the entire state. It was in this incredibly powerful position that Vullo spoke out against the gun industry, the Second Amendment industry, and the pro-gun organizations writ large, including the NRA. Now, in the wake of the 2018 school shootings in Parkland, Florida, Vullo basically went on record as making her desire known that any financial institution that she regulates should distance themselves from pro-gun organizations, and she actually investigated several insurance companies working with the NRA. She also warned banks and other financial agencies and institutions, including insurance companies, that, hey, by the way, doing business with the NRA could lead to heightened reputational risks. Vullo's warnings and investigation, as a result, caused banks and insurance companies to dismantle their partnerships with the National Rifle Association because they naturally and predictably feared losing their New York licenses if they continued business as usual. So we're dealing with whether or not the First Amendment allows the government regulator to threaten regulated entities with adverse regulatory actions if they do business with that speaker. In this particular case, we're talking about the government's own hostility to the speaker's viewpoint, so the NRA's viewpoint, or the perceived general backlash against the speaker's advocacy. In other words, if you don't get on board with what the speaker, in this particular case, Ms. Vullo, is saying, then hey, what kind of regulatory backlash we're going to see here? So this on its face is going to be a First Amendment case. We're dealing with Second Amendment issues, but keep in mind, we're talking about regulatory agencies. We already saw in 2023 the creep of regulatory agencies within the financial institution trying to code credit card transactions and purchases for Second Amendment related industry issues like purchasing firearms, ammunition, as being separate on merchant processing accounts. Where do you think that's going? Have you tried to buy a firearm using PayPal? They won't let it. What good is your right going to be to own property if you're not allowed to use a credit card, a debit card, if you're not allowed to write a check for it? Because, hey, maybe on your particular account at your particular bank or credit union, they say, we support the Second Amendment. However, none of your funds deposited with our institution shall be used to purchase firearms and related Second Amendment materials. If those banks are going to be losing their licenses if they allow things like this, you can understand what they might choose to do. And I'm not defending that. I'm just saying this is going to be a natural outflow and consequence of it. So that's the reason why, yes, this is a First Amendment issue, but this is still very much remains a Second Amendment, and well beyond that case as well. I do expect a good outcome on Vullo. All right, guys, you waited for this. Here's the big thing. We know that the U.S. Supreme Court in the June 2022 decision, the Bruen decision, B-R-U-E-N, came out and instituted a sweeping new methodology on how courts, lower courts, state courts, federal courts, you name it, how courts are supposed to analyze constitutional questions surrounding Second Amendment regulation. In other words, how to determine whether or not this particular law that regulates your ability to carry or something like that, or the state's ability to ban a particular firearm or something like that, is going to be considered constitutional, or whether or not it's not constitutional and the law gets struck down. History and tradition test. What I want to see, and this is going to be far more meaningful, I think, than any of the particular outcomes from these cases that I anticipate will be narrowly tailored. Vullo may go bigger in its scope just because it's a First Amendment issue, but I do expect some narrowly tailored decisions when it comes to Rahimi and Cargill. The really big test for these is going to see, how does the court rule? What part of history and tradition did they use? Do they use a history and tradition test, or do they go off of APA Administrative Procedures Act grounds or something like that, right? If they do administer the Second Amendment history and tradition test, what era are they pulling laws from? Are they pulling from early Republic up till, say, the 1830s? Are they going to Reconstruction, 1868 when the 14th Amendment was passed, 1870s, 1880s? Are they going all the way through the 1960s, the Gun Control Act? What are they going to be blessing as ball or strike? Because the contours of where they set that is going to decide so much gun regulation and so much gun control law as either being constitutional or unconstitutional for years and decades to come. So guys, I realize most of you watching this probably do not have a domestic abuse injunction against them. Most of you watching this probably do not have a bump stock. Most of you watching this are probably not financial institution representatives in the state of New York or something like that. But not only is it going to be so incredibly important what the U.S. Supreme Court says to the outcomes of these cases, but going to the big picture, it's how do they get there? That's what's going to set the battlegrounds. Guys, thanks for making it to the end of this video. If you haven't already done so, please click like and comment down below. Where do you see these three cases going? What do you think I'm getting right and wrong? I look forward to reading and joining that discussion. And now to a quote of the day, who comes from one of my personal favorites, Roman Emperor Marcus Aurelius. Quote, "You have power over your mind, not outside events. Realize this, and you will find strength." Thank you for finding the strength to make it this far, and I will see you in the next one. All right, so we're gonna do this fast. I can't do this with a smile. That's gonna look weird. All right, professional face. We're professionals, Derek. Yes. Pull it together. 100%. So we're just gonna skip ahead to the fact to the. I had like some candy 20 minutes ago. Yeah. Was it a mint? No, it was gummy bear, like a Haribo or a gummy bear, and it's kind of stuck there. So. It's not stuck there. It's just. It's making me salivate. The second case is Garland. I blame Merrick Garland. Just, if you want to put that in the blooper reel, go for it. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.